call us to order. We are now in public session and welcome to the 6th meeting of the Committee for Justice. Not sure if we've anybody expected to come in. Members should be aware that the committee will be recorded and broadcast throughout Parliament buildings and online. And I would advise you that I will propose that the agenda item on the overview of legislative consent motions and memorandums will be in closed session if agreed, and so that would not be broadcast. Are members content to agree to that?
Agreed.
Thank you. Everybody's, as ever, welcome to use mobile devices provided that they're on silent and airplane mode and everything is muted. And you can connect to the Assembly Wi-Fi. Password details are available in the gallery rules. I don't think there's anybody in the gallery who's a stranger to us, so it's fine. But anybody who does come in for their information should be aware that it's not permitted to take photographs or record any of the meetings. Today we propose to hear oral evidence from the Right Honourable Dame Siobhan Keegan, the Lady Chief Justice, who is with us presently, and officials from the Reducing Offending Directorate of the Department of Justice. These sessions will be recorded by Hansard, and I would seek your agreement for that. Thank you. Members, just a reminder that we're obliged to declare financial or other relevant interests which might reasonably be thought by others to influence our approach to any matter under consideration. If anybody has any items of interest to declare in relation to today's business, could you please do so now, or indeed when the particular matter arises in the meeting? Does anybody have anything to declare at this stage? Could I declare that I have an immediate family member who works in the legal profession? Thank you. So agenda item 1 is apologies. We have apologies from Alex Easton. I'm not aware of any others. And before we just proceed, can I check that Sinead, who is attending remotely, can hear us now? No, we'll try again in a moment. Agenda item 2 is the draft minutes of the meeting held on the 14th of March, which are at pages 5 to 12 of your meeting pack. Members, are you content that the minutes before you are a true and accurate reflection of the proceedings of the meeting on the 14th of March? Thank you. With that consent, then I will proceed to sign. Are there any matters arising? No, thank you. And so we move to agenda item 4, which is oral evidence from the Lady Chief Justice of Northern Ireland. So I would like to welcome the Lady Chief Justice to our meeting today. Please step forward, Chief Justice. We look forward to hearing from your presentation. Members have been apprised of the issues we discussed at our meeting last week with the Chair and I and yourselves, and so they're familiar with those topics. We look forward to hearing from you, and then at the end, if you're content, we would have some time for questions. Is that okay?
Yes, certainly.
Thank you very much. I'll hand over to you.
Well, firstly, thank you very much for the invitation to speak at this committee. I am delighted to be here. I understand I'm the third Chief Justice to appear before the committee of this committee of the Assembly, and I do hope that we can have a constructive discussion, and it's very much part of my role to engage, so thank you. I think at the outset it is important to state that in accordance with constitutional conventions, I obviously can't discuss policy issues. I can't discuss individual cases, as you will imagine. I do want to, however, work constructively with the committee in an open and engaged way as best I can. Before we turn to the questions that you will have for me, I thought I would outline some of my priorities, and you've probably heard this theme before, but some of them are, of course, dependent on funding. That is, funding either of the judiciary or the Northern Ireland Courts and Tribunal Service. And I suppose at the outset I should say that I understand in making these comments to you that any request for funding for justice clearly has a knock-on effect on other departments. I do know that, in particular health and education. But I think at the outset, can I highlight a number of points that strike me as particularly important in terms of context of what I want to say. I think we are all aware that compared to other departments, justice figures are fairly stark. Whilst the total Northern Ireland block grant has increased by 43% in the last 12 years to 2023-24, the Department of Justice has only seen a 3% growth in budget allocation. I doubt I'm the first to make this representation to you, but I think it's worth remembering at the outset. Health and education, which are of course very important departments, have grown by 70% and 45% respectively in the same period. What does that mean in real terms? Well, in real terms, the Department of Justice's 2023-2024 budget is around 423 million below where it should have been if it was keeping pace with inflation. You've already heard from others about the recurring theme of serious underfunding in the justice system. So I'm not going to say too much more about that, but I do think that there is now a significant risk to the ability to deliver services to support the administration of justice, which will have ramifications, as you can understand, for the provision of fair and expeditious justice for citizens. So those are my opening comments, which really set the context of any justice debate currently. I want to move to something which is a perennial issue that I've spoken about before, and I imagine many of your constituents raise with you, which is delay in the criminal justice system. The impact of that on victims is not lost to me. As an independent judge, I must note, and I do note, that it is important to remember that central to the rule of law is the concept that citizens should be equally treated before the law, and that legal obligations and basic rights apply to all. And this extends to victims, witnesses, and defendants. So I'm conscious that the impact of delay is raised consistently with you and with me. The problem with delay that is particularly pertinent and is of great concern to me is the impact that it can have on attrition rates within criminal justice. I'm also aware of the impact on the other side of the debate on the remand population. That leads to increased pressures on our prisons. It leads to some issues in relation to human rights of people being on remand. And these are sometimes cases involving very serious offences. Just on this, I want to say that I continue to work collaboratively with all of those involved in the justice system on these issues with a view to trying to deal with delay, and in particular with a view to trying to tackle delay from the start of a criminal justice case to the end, so end-to-end justice considerations. That's from report of an offence to disposal in court. So that's quite a wide remit. The court stage, as you may or may not know, is only one of 5 stages within that. So there are other stages involving investigation and report and decision to prosecute or not that come before the court process. I'm a member of the Criminal Justice Board, which is a very useful organisation because it brings together all of the justice partners and all of the bodies that operate throughout these 5 stages. And I think it's fair to say we can see that there are systemic issues, and we are engaging collaboratively to try and deal with them. By that I mean me in terms of the courts, PPS and police in particular. So I engage with the work streams through the Criminal Justice Board, but I do also separately engage with other organisations who have a particular interest in this issue of delay due to the victims who approach different organisations. So I thought I'd give you a few examples of this. The first relates to work being undertaken by the Commissioner Designate for Victims of Crime. Jerry Hanna has met with me on a number of occasions. She also recently attended a meeting of the Criminal Courts Liaison Committee where there was a discussion about issues that she has raised with me and that victims have raised with her. These relate largely to issues of third-party disclosure within criminal justice. Victims are particularly concerned about disclosure of medical and counselling records. That's a practical issue that we have to look at. But there's this broader panorama of the re-traumatising of victims within criminal justice. And I think there's a very strong and potent issue there that we have to deal with. So I continue to engage with Jerry Hanna, and it's been very purposeful. The second example follows my meeting with the Director of Public Prosecutions recently, and again I have ongoing meetings with Mr. Heron, and this is about early engagement and better case management to try and deal with delay in the criminal justice system. And I've looked at that broadly with him. We've thought about looking and visiting collectively other jurisdictions to see how we can perhaps adapt our practices. We've thought about, with the help of Glyn Capper and Court Service, a better monitoring form in the Crown Court for collecting data about why cases are adjourned or about why they're taking too long. I did some specific work on this through my office, looking at cases in the Crown Court and adjournments. And I'm quite content that there's no adjournment culture on the part of judges. Judges want to get on with the cases, but there are some issues that are clogging the system, principally with cases not being ready due to disclosure issues. And the data would show that there are different applications made for adjournments coming from prosecution and defence. So we do now have some empirical evidence to work on to then try and deal with the issue. So that's the second area. The third area that I've engaged on recently that you might be interested in is with the Director General of the Prison Service, Beverly Wall. And she's obviously spoken to me, as I've already mentioned, about the growing prison population and what the knock-on effects are of that. One issue that she raised with me, which we've actually worked out on a practical level, was bail courts sitting on a Friday, releasing late on a Friday afternoon, and the people released having no access to housing or services and immediately reoffending. So I got that issue very clearly articulated from Beverly, and I've now changed the listing to a Thursday rather than a Friday. So that's a win that we've dealt with an issue collaboratively and put in place a different structure of working that I think will help. Might be a small gain, but it's important nonetheless. So criminal justice is a large part of this address to you, given the issues about delay. I don't want to lose sight of the fact that there are other areas in the courts that are of interest, I think, to this committee and to people. There are still some delays in family justice, and I'm alive to that. I'm also alive to the delays there, how they may adversely affect parents and children. If ever there's an area where there needs to be early intervention and early decision making, it is family law, from my own experience. But I did want to mention this and assure you that it's on the agenda with the Shadow Family Justice Board. One area in this sphere that is a recurring issue is the resourcing of social services and guardians to help within family justice. And that's vital to have that in place in these cases. That service from those agencies is vital. Finally, just in the wider context, I recognise that family and civil courts in Northern Ireland also need to be fully resourced and structured. And the recommendations of the Gillen Review are there for that, for specialist courts to assist. Specialist courts, for instance, in family law would assist people who've suffered from domestic violence or coercive control. And also in civil law, we can't forget that many people are affected by law outside of the criminal arena, who may have an injury at work or a car collision or some other case that's very important to them. So I am alive to the issues, not just in criminal law, but in civil and family law. On the wider plane, the principle of open justice is something I have spoken about before, and it's obviously very important to me, and I think the reason for that is fairly obvious. It's to maintain public confidence in the justice system. I'm a strong proponent of it. You may have heard that I started a pilot to look at some filming of sentencing remarks in the Court of Appeal, and we've nearly finished that pilot. It finishes tomorrow. We looked at 4 cases, not for broadcast, to see whether we could roll this out. And I personally think it's a good thing. It would allow people to see how the courts operate and to hopefully get some explanation orally as to how sentences are reached. So I'm hoping that this will progress positively. It does need legislative change, and I've spoken to the Minister about this, and she is encouraging of the project, but the next step is legislative change to allow for broadcasting. It's not a one-size-fits-all, let me say, and it would be monitored, and I would be managing it, and it's not for every case. But I think we're behind other jurisdictions on this, and I personally think it's time that we should move on it. On the open and transparency piece, another aspect of that, I think, is communication with victims within the justice system about what's happening in their cases, victims and witnesses actually. And having engaged on this, I think this is a perennial issue. I'm concerned that, particularly in criminal justice, victims feel, and a high percentage, it's over 50%, feel that they're not being updated fully on what's happening in their cases. That adds to the stress of an ongoing case. And I'm fearful that that can lead to re-traumatisation or dropout rates rising within criminal justice. So I have spoken to the PPS and the police about this, and I think it's achievable with not an enormous amount of effort to set up more robust and effective communication systems. One example of this that victims have written to me about or whenever the court venue changes and that hasn't been communicated until the last minute, or there has to be an adjournment because a case isn't ready. So I'm hoping we can make some improvements through collaborative working on that. Problem-solving justice is another particular topic that I think is important within our system. The importance of this is really to avoid lengthy hearings, to have early intervention, to have early engagement in criminal justice, to have early intervention in family justice. There have been a number of pilots on this. The Drug and Alcohol Court in Belfast, which I observed myself twice, has been really a revelation. And the point sometimes is made back to me, well, is there not, recidivism in this area? Is it a small gain? I'm not so convinced about that. I think even if there are 1 or 2 people who succeed and get through this and aren't back into the criminal justice system in, the month, it's worthwhile. And I've seen it firsthand, how the judges, probation encourage people with supports to deal with their addictions. So I've always been slightly concerned that these areas remain as pilots, and we haven't embedded them fully within our system. The Domestic Violence Court is another one that is piloted, and we could probably build on. So that's an important area for me. It's along with modernisation of the justice system. I'm not going to speak at any length on that. There are papers which have been created by the court service in liaison with my office on this. We work together on it. It's a very important part of the justice infrastructure to modernise, and we're committed to it, and I think that's all well in train. Can I mention just finally a couple of other areas that I think are important and I'd like to flag with you? The first is the issue of a Northern Ireland Law Commission. Now, we haven't had a functioning and effective law reform body since 2015. So a decision was taken then by a previous Minister of Justice to wind down the Commission, and that was to prioritise services as a result of pressures facing the Department of Justice. But I am concerned about us being out of step with other jurisdictions and missing out on a law commission. So we're the only jurisdiction in the United Kingdom and Ireland without a functioning law reform body. There is some economic analysis that has highlighted the benefits of meaningful law reform to the economy, to society and to businesses. And also there are issues out there that are requiring a specialist body such as this, I think, to look at whether there should be reform to law. There are also projects in sister law commissions ongoing where Northern Ireland is left out. So I'm very clear that it would be a benefit to us to re-establish this. I think the other law commissions do keep our designated judge in the loop on what's happening, but we're not at the table on this. And I think Northern Ireland loses out having law reform on the agenda in this structured way. I also want to speak briefly about a matter that is of immediate concern to me, which I have raised in correspondence with the Minister. That is the need for additional judges, specifically county court judges. And this ties in with what I've said about delay in the criminal courts and, of course, backlog, which came about as a result of the pandemic. But I think there's also a broader picture here, because the complexity of Crown Court work has increased substantially in recent years. That's because of the legislative changes that have been made, the serious nature of much of the work. I think also the ability for victims to come forward has been recognised and supported. So we do have more cases in the system that are more complicated. County court judges are also dealing with murder trials, which would previously have been heard by High Court judges, and hearing most of the non-jury cases. I am now deploying 15 of the 18 county court judges that I currently have, most of the time to hear criminal trials. The statistics show a real increase here, because the Crown Court is now dealing with defendants at a rate of nearly 64% higher than pre-COVID, and it's predicted to recover from the backlog built up during COVID by January 2025, but the rate of cases coming in remains greater. The statistic that we have on that is that the overall number of defendants in the court system is now 45% higher than pre-COVID, and that is adding to the burden of work, delay, I think, unsatisfactory waiting times that we really do need to correct. I would also just point to the fact, which I'm not sure will be lost on you, that this cohort of specialist judges are dealing with a constant caseload of historic serious sex offence cases. They have these day in They're very difficult for victims, as we know, but they also are difficult for the profession. You have to be specialist to deal with these, and the judges are very conscientiously working through them. They are also dedicated to prioritising these cases, and a success story on that front is the protocol to deal with complainants who are under 13, now extended to under 16, and the timeframes for those cases is really a great example of how we can fast track and prioritise cases to avoid re-traumatising these young children and to get them through the system. So that's a success story, but the knock-on effect is that people are working really hard, and there are other cases that don't involve this age of complainant. And I am concerned about the effect on recruitment and retention if funding isn't provided for additional judges, because the current cohort are carrying a substantial burden in dealing with these cases, helping to reduce delays as well in our Crown courts. So I understand this is a difficult point to make at a time when funding is difficult, but I do feel strongly about it, and that's why I wanted to finish on this note today. I've written to the Minister about it and asked her to look at it for me. I think it would be of great benefit to our system, and in particular to dealing with delay and serious sex offence cases, if I could have that support. Finally, can I say that I in relation to all of these matters, have very much benefited from collaborative working with the court service, with the Minister, with the Criminal Justice Board, with voluntary agencies, with the profession, and I look forward to answering any questions you may have in relation to anything I've said or anything else I can help with.
Thank you very much, Chief Justice. Usually in these circumstances I go last, but last week I learned my lesson as time. So for once, I may use my chairman's prerogative, if that would be all right.
Yes.
I suppose a couple of questions. I'm very interested in the issues you raise around the Northern Ireland Law Commission. I'd be very interested to hear what you could envisage that would do, and the types of benefits that you consider that would bring for Northern Ireland.
Yeah. I mean, I think there are issues that are UK-wide that Northern Ireland should be cited on in terms of law reform. Coming down the line, there are going to be lots of issues arising as a result of regulation of our profession, use of AI. There's a consultation, I think, in the England and Wales Law Commission about driverless cars, which is just an indication of where we're going and how law has to adapt to changing societal norms. But other areas I'm aware of that, cross boundaries, electoral law, surrogacy law. We have other issues that just affect citizens day in, day out, that they may write to you on and say, why are we different from what's happening in other jurisdictions. There's a cross-border element as well, I think, with the Republic of Ireland Law Commission, who have looked at issues that cross over our jurisdictions. So we did in the past have a law commission functioning, which dealt with a number of legal subject matters that have been of use. Bail reform was one. There was a report on bail reform. Land law is another one, and there are lots of things that come up in that area that are perhaps not as highlighted in the press, but are very important to people about property, land law, that type of thing. So I think we should be at the table, frankly, on this. And I understand that the other heads of Law Commission are exercised about this as well. They do invite us as a courtesy, but without the infrastructure and the funding, there's very little we can do. And as I said, it's been brought to my attention that there is data and empirical evidence that this does benefit and helps. I think it probably speeds up any law reform projects that would be taken to the Assembly for legislation as well.
Thank you. So the other issue that I wanted to raise with you, your visit today is timely with us because yesterday there was the second reading in the House of Commons on the bill to deal with Horizon. Yeah. You'll appreciate that from our perspective, Northern Ireland is not included in that bill, despite the fact that our First and Deputy First Minister, our Justice Minister, our MPs, and I think probably a number of Assembly members would be very keen that people who have suffered a wrong in Northern Ireland would be included in that bill and would be covered by it. Yeah. Might I ask, Lady Chief Justice, as I suppose on behalf of the judiciary, yeah, would you be amenable to Northern Ireland being covered by that law?
I think I have to be careful not to step into a policy area here, but I can say a little about this. As my counterpart in England and Wales indicated to committee in Parliament, there was no green light for this type of legislation given by the judiciary as such. And that's, you can understand, due to constitutional convention. These are convictions that would be quashed by legislation. So that didn't come from judiciary, but I understand that there is the bill now going through Parliament. The position in Northern Ireland is slightly different from other jurisdictions because of volume. There are we think about 28 cases in Northern Ireland related. I have in the Court of Appeal dealt with 2, which were quashed last year, and there's 1 pending. So there could be another 23, 25 cases in the system. There's no issue with capacity in Northern Ireland. I actually don't think there is in other jurisdictions. If the courts were asked to deal with these cases, we would deal with them, and we deal with them quickly. I suppose the issue now is legislation having been drafted. I think it is unfortunate to think of people in Northern Ireland being left in a different situation from people in other jurisdictions. So I understand that point because this is it's been described as a very stark recent miscarriage of justice for lots of people, and I can see the issue about not treating people in different jurisdictions in different ways, if that answers your question. So I would be a bit worried about that we're on different planes, but it's not for me to create policy or deal with the practicalities of it. I just hope that there's no delay for Northern Irish people who would have the same right to a compensation package as well as having their name cleared as people in England would. That's going to be very important to people.
I think that, what you've said is absolutely key. The issue is timing, and why should people in Northern Ireland be disappropriately disadvantaged because of timing and because we're not included in the bill. So thank you very much for that. I just have one more, and again, I'm not clear whether, if you choose not to answer, so be it. At the meeting that the Vice Chair and I had with you, I omitted to raise the issue of court bail. And I suppose any views that you may have, if you would care to share or otherwise, around the effectiveness and the enforcement of court bail, and whether there could be changes or improvements made in that area.
Well, court bail will be determined by each judge on the basis of the facts of each case, and there's quite a clear set of well-established criteria emanating in domestic law and European law about whether bail should be granted, firstly. And secondly, if it is granted, on what conditions. And we have quite a remit to impose conditions on anyone who achieves bail, which are designed to militate against a risk that's identified, usually a risk of reoffending or interference with witnesses. If those conditions are breached, the person has to come back to court and faces being remanded. I think the courts are very alive to trying to regulate bail as best as best they can with conditions. I mean, I can't say that every case results in people abiding by conditions, but I think anybody who breaches bail conditions would know quite well that there are serious repercussions and they're unlikely to achieve bail again, or they'll have a much harder job. I'm not sure there's much more I can say about that.
No, that's fine. I just wanted to establish, if you felt that there was improvement, or if you felt that things were working smoothly, you'll appreciate, I suppose, from our point of view, the issue of people being given court bail, whether it's police bail or court bail or some kind of bail, sometimes impacts public confidence massively, dependent on the type of cases. So I just wanted to...
Yeah, well, I mean, I understand that, but there is a presumption of innocence pending a trial. And I can understand that it is difficult for people to perhaps rationalise why someone is released pending a trial, but the court weighs all of that up and has to, apply a fairness standard to both here. Absolutely. In these cases. So the person accused, who is presumed innocent until found guilty, and also the victim. And I think by and large we get the balance right.
No, I think that's really helpful. Actually, I think it's helpful for the public to hear what you have to say on that, so thank you for that. I'm going to open up now. The first one I have on my list is Doug.
Thank you. And thank you, Lady Chief Justice. I mean, it's really insightful, and you have an awful lot going on. I wasn't going to raise delays in justice because we talk about it a lot, but you did raise it, and because there is a confidence in our criminal justice system which is being undermined because of delays in justice. I suppose my question is expanding that a little bit and maybe looking forward slightly, because we're not in a good place now. I'm hearing that the Criminal Bar Association may well take a vote tomorrow to go down to a 4-day week. It'll be interesting to know what you think that effect that will have on us. That's over the pay dispute, if they did vote to go down to a 4-day week. But when you talked about the delays in our criminal justice system, and I've been hearing this for many, many years now in this committee. We've all talked about this for many, many years in this committee. The reality is it takes us twice as long in Northern Ireland to do what they do in England and Wales, and I don't quite fully understand that. But one of the things I was going to ask, and again, I don't know if you can answer this, but I have a real concern about this reduction in sentencing of a guilty plea. If the guy makes the guilty plea the day he goes to court, after using all of those resources, delayed all of those things coming forward, and then gives a guilty plea and gets a third off his sentence, is that something you think we should be looking at?
Right, there are a couple of elements
there is, I'm sorry.
Firstly, I agree with you. We have been talking about delay for a long period of time, but I do think we're now at a point of trying to deal with it robustly. Secondly, my running of the courts dealing with delay and the current cases depends on the legal profession. They are a really specialist criminal profession, criminal bar and solicitors. It would be wrong of me to start talking about their issues, and I know they have some issues, but we work together, and I wouldn't want to see what we've got put off track, let's say. So I hope some of the things that you've alluded to won't come to pass. Everyone needs to be supported in this and funded. So I think that's really all I'll say about that. You've asked me then about guilty pleas. Now, there is a statutory provision which a court has to take into account in relation to giving a reduction for a plea, and you can imagine why that is. The legislation refers to the fact that it obviously saves time and court resources. That's actually what the legislation says. It also says that the reduction to be given depends on the stage at which the plea is given. I think in Northern Ireland we have maintained a good system of discretion on this. We don't have hard edges on it. There was a case that went from our jurisdiction to the Supreme Court a couple of years ago of Mon, which referred to maximum credit being given for somebody who pleads early is very important to the victims in cases in any event. And there should be a sliding scale up to the day of trial. However, it's a nuanced issue because each case is different, and in some cases the benefit of a guilty plea, even if it is at the door, is really strong and important. So judges do look at this. It's not an automatic, third if you plead at the door of the court. In fact, it would usually be less than that. But if you pleaded at arraignment, for instance, when the charge is first put to you, or if when you were interviewed with the help of a solicitor you said, I am going to plead guilty to this, I think there should be good credit. I think it helps the criminal justice system operate. We have lots of delays in cases that need, forensic evidence. I'll say drugs cases, for instance, or phone evidence. That if there was an early plea, I could see a real benefit in enhancing credit. At the same time, I understand that some victims feel hard done by in a way. I'm not really a proponent of thinking that the saving the victim giving evidence at the door of the court is the best argument. I think it's a broader panorama, and I think judges are alert to that. And I don't like the idea of anyone feeling hard done by in the justice system, but at the same time, we do need guilty pleas to keep the system going, and they are very important as well in terms of vindication for victims. I do see a real strength in that. That's a long-winded way of saying it's not automatically a maximum credit case at the door of the court. It actually, it shouldn't be presumed. It may be in certain circumstances, depending on fact, if a judge thinks it's merited. And that's where I come back to the importance of the public understanding sentencing and sentencing remarks. I'm keen on that. That's my project in terms of the televising of some sentencing remarks, but also making them available, so people can see what the actual rationale is down to why. But I understand the point. I just think our system is better by being flexible on this.
And I guess if I can, and just to follow up on that, it's really the point you raised yourself, and that is, how do we protect victims and witnesses who go through all of that trauma, getting ready to give evidence, and then the day they're giving evidence, somebody pleads guilty and it all just stops dead. You need nearly a cut-off before that to say, look, you're going through here regardless, that people need to have their moment in court if you've dragged them all the way to this last safe moment.
I know, I agree with you, and that's why we do have rules of thumb, that it isn't maximum credit at the door of the court. It's not to be presumed. If a judge is giving that, there's got to be a really strong reason for it. It reduces back. You can get your you're definitely going to get your maximum credit if you at the police station or an interview say, I'm guilty to some of this. Then arraignment is the first port of call in Northern Ireland where the charge is put to you. That there should be a sliding scale up to trial, but I just think it's hard to set hard and fast or bright line rules on it because of the complexion of each case. And
then just, if I can, just one last question, and it's just again something you've said, which I think is important, because you're talking about televising and letting people see the sentence being handed out and understanding that, and it just follows on from that, Lady Chief Justice, is because some of the remarks from the judges in sentencing have not been great, and we all remember the find a wife comment in a sexual offences case, and in fact I wrote to you in regards to that and asked for a meeting, which we didn't have because I understand the reasons for that, but we talked about the training for judges, and you did training for judges, and that's really important. But the question is, I suppose, is that training mandatory? Do they have to attend it, or do they have a choice to say, I'm not going? And if they don't attend training, do you have the ability to say, no, you must do this mandatory training yearly, twice yearly or something?
Well, I did intervene in relation to that case, and I did bring in the training. I've changed the way we train in that it's days where I have the court list cleared, so you have to go, is the bottom line. And that's been really good. And I usually do it around about just before holiday times, so the profession are quite happy with me doing that, but all the judges come. That's really important. Well, a part of my rationale for in increasing judges as well is actually to have more time for judges to do this sort of thing. It's really important. I don't think across the board there are issues here that are of such concern that I have to do anything more, let's say. I've got the training programmes on track. The next one you might be interested in, I'm going to have a day with the judiciary and the bar about proper cross-examination of vulnerable witnesses using the Advocate's Toolkit and third-party disclosure. So I'm going to do that as a joint. And again, courts won't be sitting, so you have to go. But, by and large, I think judges are responsible. There are some days that aren't the greatest days. I don't see very many of them, to be honest with you. And if I do, I'll take action on it.
Yeah, and in fairness, you're probably right, but it's always the one, which undermines it. And look, and it takes us into a bigger conversation we can't have today, and that is the whole sentencing issue. And there is not a huge amount of confidence out there in regards to sentencing, because I think certainly for sexual offences, it's lenient, which is a general perception. But look, that's something I think for another day. But it's something that we'll probably have to discuss. But listen, thank you.
All right.
I'm also conscious that we have 15 minutes and a full list. So again, I would remind members to avoid the commentary and hit the question, please, just to try and make sure that everybody gets the chance to ask the things that they wish to raise with the Chief Justice. Morris.
Thank you very much, Chair. Thank you, Lady Chief Justice, for coming before us today and giving us a presentation. You mentioned family law in your presentation there, and I have a query. You may be able to answer it, you may not, and that's around the unfair treatment, the perception of unfair treatment that fathers receive from the courts in custody cases where they, and I actually agree with it, the children rightly belong with their mother, but there are fathers out there who want to play a full part in their children's upbringing, and they seem to be penalised by the judicial system, which sometimes can preclude them from full access to their children. Right. And I was wondering, had you any thoughts on that?
Well, I do, because you may or may not know that I used to practice at the bar in family law, so I did a lot of this work. I don't see an imbalance in relation to how the law treats parents. We had the Children Order enacted here in 1995, which was really important because it changed the whole structure. You've got parental responsibility. You can be a residential parent if you're a father or a mother. I think, though, as you've appreciated, most of the cases probably involve either joint custody currently, or shared care, or mothers having custody or care and fathers having contact. I don't see the law as discriminating against fathers on that. I think we have developed a law whereby the right of the child is to have a relationship with both parents, and that's what should be at the heart of it, subject to safety issues. If there are issues about somebody not being good for a child or safety issues vis-a-vis between parents, and there's a big debate about this, about the responsibility of parents towards each other and whether that should impact on contact. But I'm fairly clear that we as a jurisdiction are tuned in to the perspectives of both mothers and fathers, and for what it's worth, I've both represented mothers and fathers in cases and judged on cases where both sides have succeeded, if you know what I mean, both in terms of having care of children and contact.
Thank you very much, Lady Chief Justice. But I've had a few cases come into the office whereby the father and the mother, it's not a good relationship between the parents, but it's a good relationship between the children, and that poor relationship at parent level is impacting on the
Yeah.
health of the father. In one case, I had a fellow who was deeply depressed and on the verge of suicide
Yeah.
through being denied access to see
Yeah.
his child.
I find those really heartbreaking. I remember representing a man in particular who walked away because he'd had enough. And I said, look, I want to get you contact. You should have contact. Mm-hmm. That's hard, but I think that's where, other agencies come in. Help from the court children's officer in courts is really important. Help from social services, guardians in public law cases. Help from wider family as well tends to sometimes unlock the impasse. We also, I should say, have brilliant child contact centres in Northern Ireland, which are a neutral environment to try and set up contact. Some of the sting in those cases is due to handovers, and you've got to take the two parents away from each other to try and promote the relationship. But I would be sad if men felt, disenfranchised in this. It's certainly not the ethos of our family courts in relation to contact, because, as I say, it's the right of the child to have a relationship with both parents.
Thank you very much. I have a couple of others, but I'll leave it because there are others here.
Thanks, Morris. Appreciate that. Ciara?
Just to follow on from Morris, just a quick one, because I'd had it on my list. You had mentioned about, obviously, family justice and delays in it. You said what would be required is resources and two family support services, and obviously guardians in public law. So just maybe level type of resources you think is required for that. Secondly, then, in relation to the delays again, disclosures, just highlighting, obviously you mentioned the 5 levels, the 5 tiers. Where is the biggest delays in relation to disclosures, and between what organisations, and how that could be sped up? And then just finally, obviously you flagged up the NI Law Commission. To have it re-established, have you any idea regarding cost, scale, size, what's required? I'm quite new. This is my first time on justice, so I'd be interested. I wasn't aware of the previous commission back in 2015. So what would be size, scale? Thank you.
Okay, a couple of questions there. Firstly, about resourcing family justice. There's a crossover with, health on this because social services need to have enough people at the front line. They don't in offices have enough to take on the family and child protection work. Guardians are similar. There's a backlog of appointments which delays cases being dealt with, which I think they do advocate about. The bigger picture, though, is support services, actually. Things that I find are most effective in family law, if you drill down, are help through organisations with the issues of, say, neglect in families that could actually be dealt with. Sure Start used to be on the front line doing this type of work. I'm not sure if they've been replaced, but it'd be a similar types of organisation to actually assist families, to have early intervention, to prevent them coming into the care and family system. It's a give. There's been, since I started practice 30 years ago, there's been talk about early intervention projects and putting the money in, and I think that the principle is there, and I think everybody is well motivated, but it's how do you access it for people who are vulnerable and may not be able to advocate for themselves, and how do you sustain it? It would be unethical to set somebody up and then take away support. People need ongoing support to keep families together. I'm very strong on this, and I see cases come into the courts where I think if they had had a bit of help at an earlier stage, it would never be before the court.
I probably need to declare, obviously, really, till we get in this conversation, but obviously my previous job I would have managed the family support hub. These cases would have been core, and it was trying to advocate and support the parents at that early stage.
Well, then you know exactly what I'm talking about.
But obviously, you're well aware that's 25k per year through the Department of Health. That sustains family support hubs. That's what's there. So there isn't that cross-departmental investment into it, but it is probably an area.
I'm not sure it's a massive amount, but it could make such a difference. On the law commission, I don't have an actual figure, but I can get that for the committee as to how much that would actually mean in monetary terms. So I don't want to speculate on that.
Right. But even scale and size, resource.
Resource. Resource. I have appointed a judge who is in shadow. So I have a judge in place who keeps up the connection. And there would be a staff team. I don't think it would be too many. I think in the past there was one particular person who was the secretariat, and then what happened was other interested people, academics, lawyers, came on board in the Law Commission, and that could be on an ad hoc basis in relation to a project. If it was a specialist area, you as the chair of it would bring in people. I think there was a committee though of specialist people involved in it. There was a secretariat and there's a chair. I actually have a chair in place, ready to go and very willing to go if we got it set up. But I can provide some further information on that.
Yep, okay.
Thank you.
Just on the disclosures?
The disclosures in relation to abuse.
To delays in the justice process.
A disclosure of...
Is it disclosure of information, whether it's between
yeah.
case and I to court
Yeah.
to prosecution?
In the criminal field, it's usually what's called third-party disclosure. So if there's a criminal complaint, there would usually be an application for disclosure, say from social service records.
Yeah.
So that causes a bit of delay. The other delay on disclosure, to be honest, again, I think it's a product of our modern world. Phone records are used a lot in criminal cases in this area, and that takes a long time to triage. So that's an issue that builds in a delay. But third-party disclosure is the biggest issue, I think. And I suppose, phones and other sort of evidence gathering that takes a while.
It's obviously a key area that requires
It is the main. It is as far as I can see, if you drill it down, it's the main issue that stands in the way of cases getting on.
Okay.
Deirdre?
No, thanks very much for your presentation. I suppose just a couple of issues. I mean, I think we all get the issue around funding and the pressures that the department and the services under it are facing at the moment. So we're well in tune to that. The other issue I suppose I wanted to touch on was outside of the funding demands, it's the structural changes that need to happen that often or sometimes may not need money or may need money to transform, but what are the outcomes they're going to achieve? So it's really how we can monitor that. So the Commissioner for Victims of Crime designate who was in said that the system isn't designed with a victim focus and there are cultural changes that need to happen. So it would just be to get your view on that in terms of would you agree that there needs to be system change beyond just the resourcing, and if so, in what areas, and how we can start to change or have a cultural shift, or what your view on that would be in terms of being more victim-centred, but also on the basis of, is it even rehabilitative centred in terms of trying to rehabilitate people that go through the system to try and reduce reoffending again? So just some...
Oh, yes. Right, two areas there. Is the system, sufficiently attuned to victims' needs? I ran some training on this in trauma-informed practice because I'm committed to it and I think it's really important. I think we know where we stand on this, that we have to be attuned. I think we have, practice directions. We understand good practice on this. We have special measures in court. We have support systems. We have legal advisors now for complainants in cases, which is really good. We have remote evidence centres. As I've said, I'm training judges on this. I have to say as well, we have a brilliant voluntary sector who assist. We have Women's Aid, we have VOIPIC. I think we'll have it all. We just need to build on it. We need to make sure that victims don't feel re-traumatised by the court itself. And I think we have the armoury in place to do that with the profession. So that's judiciary with the profession. That's why I wanted to have the joint training with the profession about how you question witnesses. And I've continually tried to say, why can we not have witnesses giving evidence remotely, which would assist and move on with cases. So I do think we are attuned to victims within the system, and we can just continue to educate ourselves and educate everybody who works in the system to improve on it. And I've spoken to Jerry Hannah about a number of other things on that front, practical issues about entrances and exits to courts, more consultation facilities, and I'm aware of all of that, and I'm trying my best to, within the resources I have, to facilitate those points. But obviously I have to speak to court service about courthouses and, you know, improvements that way. But I'm aware of all of that, and I value the direct engagement. The flip side of the coin is one that you've touched on, which is those who are perpetrators within the system. You know, firstly, it's a given somebody accused has to have a fair trial. That's fine. Perpetrators within the system, however, some do plead guilty, for instance, which is of benefit. I think we need to invest in perpetrator programs. I think victims can be part of that program, not obviously the direct victim, but educating the perpetrators as to, you know, why behaviour is totally unacceptable. This is important in sex offences cases, but also domestic violence, coercive control. We need to put that in there, because the work in there, the support in there, because otherwise it's a revolving door. And, you know, part of sentencing is punishment, but another part is rehabilitation and deterrence. To be honest, I think the educative piece goes back to schools about healthy relationships. But and we do a bit of that, I think, in our jurisdiction, and that's good. But if you're in the system, you've got to have the chance to come to the table with professionals and try and change your view on things. I see too many people coming back in, and I wonder about that. I don't think they have the right support system or the ethos to think that they should change their behaviour, and it's really important. It feeds into initiatives such as rolling out more enhanced combination orders, for instance, which deal with, if there's a sentence which is under 12 months, looking at rehabilitative work rather than a short prison sentence, that type of thing. Probation are really good on this, but again, they're probably, if they came to you today, they'd say they're probably stretched.
It came last week.
Okay, well, they probably said they were stretched. But yeah, you know, we can't just sit on our hands on this, and you're quite right to raise programs for perpetrators as well. However uncomfortable that might be, is the way to change behaviour and behaviour patterns.
Yeah, no, thanks for that. And I'm sure we'll come back on these issues as part of, I suppose, just on that then, in terms of, because we have been having discussions with the department in terms of looking at delays, looking at early prevention and intervention, and obviously cross-departmental working. But are you feeding into the reform plan and the board in terms of recommendations that you would see? Is there that ongoing dialogue with the department and indeed with that board that's taken forward? We're obviously asking for the plan to be published when it's ready, so I'm just keen to hear if you are directly feeding into that. Yeah. And then the other bit for me is around, again, I know I'd raised it when we'd met, was around representation, and is the system from judges down reflective of society out there? Yeah. It's not in terms of reflective, so what work can we be doing, particularly around social class, around ethnicity, just with new communities that are here, and in terms of, I suppose, the gender element. I know there's a bit of a focus on the gender, but those other areas, because as you say, for those going through the system, in terms of the perpetrators, but then even also the victims as well, there are patterns in certain community descriptors or backgrounds. So again, is the system responsive to that, even in terms of, you know, those that are charged with overseeing it, and do they have an understanding then of the complexities out there within neighbourhoods, and is it reflective of that? So just some queries around that.
My office does feed in with the reform programmes, is the answer to the first question, and it's a dynamic relationship, and that's useful. On the second question, diversity within the judiciary is a given. It should reflect society. We are in a good place in terms of balance, terms of community background, in terms of gender. The problem, I think, just if I may say, on gender is we're at the start of a journey, I think. We don't have enough females getting into the higher judicial positions, but we have lots, and I'm very encouraged at the lower tiers who I think are going to build up. I think more than half of law undergraduates are female now. So that will work its way through. It's taken a while, but I'm committed to it. I think there are other areas that perhaps don't get the same attention that we do need to think about as well. Social background is one. Ethnicity in Northern Ireland is another. We've low numbers on that, but yet our society is changing, and I think that should develop. And disability is the third one, where I think people should be encouraged, if they have a disability, not to feel that this is beyond them. We outreach as part of the Northern Ireland Judicial Appointments Commission to the professions about making sure people come forward who might not have thought of judicial office before. There is no model or paradigm for judicial office, and we have a younger cohort, I think, of people coming forward to even senior positions and a different spread. I think we need to tap into schools and encourage students from areas that might have not thought about law, let's say, or the professions, to think to actually be supported. Queen's are involved in the Pathways project, which I also support, which is really good. So that's going into schools that wouldn't have traditionally sent people to study law, and we've had some success stories there. That's what we need, because we need to have society as a whole here represented. And I am confident that we are attuned to this. I think there's a bit more work to be done, but it's really an outreach issue. I can only look at judicial office stats from the perspective of what's the pool within the profession. So the solicitors and the barristers who are coming forward. So we need to get in early to schools to encourage young people from whatever background to think about law.
We're not going to get it now because I know we're time, but just something will come back, because you're right, we need to look further downstream as well.
Yeah.
And I suppose the issue of legal aid comes in, that we'll need to come back to in terms of how that even blocks in the impact on women in the profession around legal aid, and particularly what I suppose the Law Society had said, the high street firms and the impact in terms of payments and reviews.
Yeah.
So I would be keen to hear your thoughts at another time just on some of those
All right.
issues further downstream that have an impact.
I could speak for a bit on that, yeah.
Thanks.
But thanks. Thank you.
Thank you. Two more. Sorry, Chief Justice, we're nearly there. Stuart.
Thank you, Chief Justice, for your comments this afternoon. They've been very helpful and very comprehensive. You said to us earlier on that you had a desire to have some additional judges, but in a court system that's running at 100%, where would you put those judges in terms of the physical estate and in terms of the court resource to actually use additional judges?
Yeah. Well, there is a tie-in with the estate. I think that's why I'm not coming to you and saying I could do with a massive amount. I could do with a massive amount more. I'm trying to keep my horizons as modest as possible with the 3 that are needed within the county court, which I think can be accommodated within the estate. But I mean, if you get me going on this, the estate needs improvements as well. It's a bit like I talked about the specialist family court. But yeah, I think I can work with it on that level.
One of those things that the judges do and have done very successfully, and I remember from my previous time in this committee, particularly the work that Fiona Bagnall was doing in respect of the problem-solving courts.
Yeah.
When does a pilot cease to be a pilot, and when does it become mainstream, and who makes that decision?
That'll be the sponsoring department who are funding it to make the decision, to be honest. I worry a bit about this, as you pointed out, because I think we have so many pilots. Yes. Why are they not becoming permanent? Now, I think there's also a psychological issue with it, that if it's always determined a pilot, there's a question mark over it. Yeah. But there have actually been reports that have been analysing success on these as they've gone on. I don't think they're negative. I stand to be corrected. So would it not add to the confidence of that type of work if it was embedded as something permanent?
Yeah.
I think.
And I would encourage that as well.
Yeah.
I think pilots have got to come to an end. They've got to be analysed, the outcomes worked through, and then you decide whether it becomes mainstream or not. In terms of the remand population, you've dealt with that well, particularly in relation to the Friday situation, which has been very helpful. Some of us have been to the prison service, and we've had that discussion with them.
Good.
But there is an overall concern about the number of people who are currently held on remand, and I just want to know what relationship the judiciary has in relation to assessing that, both in physical terms of the court service, which leads to very difficult circumstances of doubling up on other issues. And I'll finish with just one final question. How many of your judges actually have been in prison to actually physically see what the conditions of a prison are like? Is it part of your training?
Right. On the last question, quite a lot have been, myself included. When I became a judge in 2015, there was a programme to visit the prisons for all new judges, and I went with a number of new judges. So quite a lot of us have been. I haven't been to McGilligan. I've been to McGabbery and Hydebank. I actually am going again to all three myself, and I'll probably take some colleagues with me. It's part of our training that's offered. I need to refresh it a bit. I think probably people need to go again. I think it's really important. I learnt a lot when I went, so I support that. Remand population, you have to be careful here that the issue of remand population doesn't drive a judicial decision. I worry, however, in some cases, the balance in favour of bail will be tipped by virtue of delay and the length of time spent, and that can cause problems too. My worry about remand is you don't get the programmes of work that you would get if you were sentenced. No. Where judges can be effective on that is to say, can this case not be fast-tracked at the magistrate's court to, is there an attitude here, are you going to plead guilty because it would be to your client's benefit? And I think my judges are quite robust on that to try and move it on. Short sentences, another issue. Are they really productive versus, a rehabilitative programme, as I've been asked about?
I think that's the fair point. A rehabilitative programme for those short sentences, depending on the offence.
It's not one size fits all.
It's not one size fits all. And just very, very briefly on the issue of visiting the prison service, having done it a few years ago and then just recently in the last couple of months done it again, the change in programmes and resources and activities that go on are incredibly good and new going forward. Yep. And I think it would be very helpful if judges had the opportunity to refresh their view and sight of what goes on inside prison. Yeah,
we're open to it, and I want to do it. We're open to other initiatives. I'll just very briefly mention, if I may, tie in with sport. I've tied in with the FIA, and I want to continue to do that to see, is there a diversion for young men in particular through sport that might keep them out of criminal justice? So all of those programmes are on my radar, and I think could be of benefit.
Thank you very much, Chair.
Thank you. Justin?
Thank you, Chair. Hi, Chief Justice. Can I take this opportunity to say what an honour and privilege to meet you, to have you here before this committee, and to congratulate you on becoming the first Lady Chief Justice in the history of the North. So well done. By coincidence, we had a group of pupils from your old school in here yesterday, and I was telling them to follow your lead, dream big, be as good as they can be, break glass ceilings. And I congratulate you on that front. You're a lodestar, particularly for young women and for girls, and you have probably positively disrupted what was potentially perceived previously as a bit of an old boys club judiciary, so fair play to you. In terms of the Department's policy in relation to delays, payment delays, how does this impact the access to justice and delivery of justice, especially for those on legal aid? I know you might not necessarily mention legal aid specifically, but give me your perspective on that, please.
Okay. Well, I can very briefly say delays in legal aid payments for the profession are problematic. They're problematic for particularly the small operator solicitor in Northern Ireland, which I think is the backbone of Northern Ireland. We have lots of large firms, but We need solicitors in our towns who need to have a turnover to run their practices. And I'm sure the Law Society said to you that solicitor firms, some could be in trouble if they weren't paid in time. And, you know, this is work they have done. In no other area would you have to wait so long if you were having a kitchen fitted or an electrician in the house. They have to be paid within a certain period of time. I don't think that's difficult to work out. For the bar problem, the bar self-employed, I worry if there are delays that it freezes out those barristers who take on legally aided work. We have a really good system here where barristers, you know, across the board do publicly funded work. In other jurisdictions, they don't. And I wouldn't want that to change. I wouldn't want young barristers to be adversely affected and leave the profession. People who don't come from privileged backgrounds to leave the profession because they can't get money through publicly paid work within a reasonable time. And so it does have a knock-on effect, because if you lose those types of people, you just don't have the diverse profession that we should have.
You mentioned serious underfunding in the justice system, and you mentioned also the risk in terms of the provision of fair and expeditious justice, which is incredible for you to say at this committee, and the backlogs which threaten to undermine public confidence in the justice system.
Yeah.
Is it not scary for you to say that?
Well, I just think it's a given at the moment that if we don't get back on track with funding the system at every end of it, we could have a problem with delivery. We already have a problem with delays. I've told you that I need more judges to really address the issue. The profession needs funded. People need law. They need law to sort out problems. They need law to regulate society. So, you know, there is always a flip side if these things are lost, dropped, not prioritised. I think they are prioritised, though. I think everybody is attuned to this. And to be honest, you know, additional funding can clearly make a difference within justice. It can be directed towards the things that I've talked about fairly easily. I don't think it's as complicated an exercise as in other areas to get that through.
And finally, you mentioned that too many people are coming back in, which is also very worrying, you know, in terms of rehabilitation, in terms of reintegrating into society, and how important the role sport can play. I'm a big supporter and believer in that as well. But in terms of that reintegration piece, getting people jobs when they come out of prison, prisoners, people who've done the crime, yes, and done the time, and come out, but they can't get a house. They can't get on the housing list because of their criminal past. How does that support reintegration?
It doesn't, and I'm surprised to hear they can't get a house, to be honest. I think there needs to be...
They can't get on a housing list.
They can't get on a housing list, yeah. There is some good work done with the housing executive at the moment with remand prisoners, that they have direct access to the housing executive, because you're right, there's a sort of pecking order, I think that's what you mean, and not getting on the list. So the prison service are alive to that, the courts are alive to that. I often actually take a lead on this by saying, you know, I will say grant bail if all of this is put in place to fast track it. People do make mistakes in their lives, and they can be accused of crimes or convicted of crimes, but they do have to reintegrate unless they're in the very, very serious category at some stage. So we have to do better on that. And to be honest, in my experience, I've seen employers come to the table in courts and say they will employ people, which is right. But there needs to be a tie-up then with housing, education, health actually is another one, given, you know, the need for ongoing mental health support probably is, or addiction support is probably at the heart of it. Actually, addiction support will be at the bottom line on a lot of the recidivism that we have, I think, if you look at the stats on it. So making sure all of that is in place if people don't have family support, which a lot of people don't have, unfortunately, in this area. Thanks, Justin.
Thank
Thank you, everybody.
Thank you.
Chief Justice, can I thank you? You've been inordinately generous with your time again today. It's been really helpful to hear from you, and we're grateful for you taking the time to come and give evidence to us. So thank you very much.
Thank you very much.
Awesome. Thank you.
Thank you.
Thanks.
Members, just before the prison service comes in, or the Reducing Offending Directorate, again, I'm really going to have to ask that we cut to the questions and not the commentary, because at this stage now we are 20 minutes behind schedule. So I know sometimes it's helpful to contextualise a question, but can we keep the context at a minimum? Because I think it's key that if you've got a question and you want to follow up and develop and probe, that you get that time, rather than just us giving our statements with things. I think it's important that everybody gets a chance to ask what they need to ask, and not. I don't like this business of, right, you've got 2 questions, go, choose your best 2. I don't think that's helpful, but we've got to try and manage the time, because obviously the prison service has been there for a while. So please bear with me. I'm not trying to be mean. I'm just trying to make sure that everybody gets a fair crack of the whip. So whilst everybody's coming in and taking their seat, I would refer members to, we're on agenda item 5, and at pages 20 to 133 of the meeting pack, and those are the relevant papers are found. So we have representatives from the Reducing Offending Directorate of the Department of Justice who are going to give us an overview of that directorate. I apologise for keeping you all late. We had a considerable number of questions for the Chief Justice, so thank you for your forbearance in that regard. Beverly Wall, who's the Director of Reducing Offender Directorate and the Director General of Prison Service. Beverly, thank you for coming. I have David Kennedy, who is the Director of Prisons. Stephen McCourt, who is the Director of Rehabilitation. We were just talking about that, Stephen. And Stephen Martin, who's Chief Executive of the Youth Justice Agency. Could I thank you all for coming, and once again apologise for our tardiness, but in the circumstances I'm sure you'll understand. At this stage I would like to hand over to you to tell us the things that you need us to hear, and then we'll move into a time of questions if that works for you. Okay.
Thank you, Chair.
Thank you very much, Beverly.
Thank you for your welcome, and we're very grateful to have the opportunity to brief you today. There are a number of challenges facing the Reducing Offending Directorate, and while these are included in your written evidence, I'd just like to take a few minutes now to provide some context to those. So starting with the prison service, the most pressing challenge facing the service currently is a significant increase in the prisoner population, and that increase is in both the sentenced and unsentenced population, and is felt most acutely at Maghaberry Prison. The prison population today stands at 1,891, and that's almost 500 more prisoners than in early 2021. And our remand population today represents 36% of the total prison population, 70% of young male population, and 48% of the Maghaberry population. As set out in the written evidence, the reasons for the increase in the population are complex and place many challenges on our prisons. Today, we have 475 prisoners sharing a cell, 375 in Maghaberry and 100 in Magilligan. And we anticipate that we will open our final accommodation wing in Maghaberry by the end of this summer. That brings me on to the second challenge. The rising population has not been matched by an increase in staffing levels within the prison service or with our partners in probation and health. So it's becoming increasingly difficult for us to deliver vitally important work to rehabilitate prisoners and support them in their resettlement back into the community. The final challenge I wish to highlight regarding prisons is the growing complexities of those being committed to prisons. We're seeing increasing numbers who have addictions and extremely poor mental health. We know that this is a growing problem in wider society, but the prison environment means that those problems are more acute there. Our staff do an outstanding job, but they are not medically qualified, yet are expected to support people with chronic addictions and significant mental health and behavioural issues. In delivering those support services, I cannot overemphasise the importance of our delivery partners, and in particular the South Eastern Health and Social Care Trust, who have responsibility for healthcare in our prisons. On the wider work of the Directorate, I'd like to highlight two areas that impact on the front line: remand and reducing offending. There are a range of factors which have been shown to have an impact on re-offending. Those include poverty, mental health issues, substance misuse, homelessness, and a lack of educational attainment and employment opportunities. Making real inroads into reducing offending behaviour requires effective partnership, working across government departments, statutory agencies, the private sector and the voluntary and community sector, and I know that all of those partners are feeling the same impacts of reducing budgets as Justice is. I've already mentioned the impact of remand on our prisons, and the prevalence of remand continues to be a concern. The Justice Permanent Secretary has recently established and chairs a prison population oversight group, and membership of that group includes senior leaders from across the justice system, South Eastern Trust and more recently the Housing Executive. Collectively, we're considering what steps will be most impactful to address the issues both at systemic and individual level. And a justice-wide working group on remand is also overseeing initiatives including the availability and use of management information and developing viable alternatives to remand to offer the judiciary. Adopting a wider cross-departmental approach will be crucial if we're to support individuals at the earliest opportunity to, where possible, prevent them from coming into the justice system at all. And finally, to the Youth Justice Agency, over the last number of years, YJA has been able to reduce the number of children in the formal justice system by working with partners using a child-first, offender-second approach. And this has helped improve the life chances of those children and reduce levels of reoffending. The focus has been on diverting children, where possible, from the formal justice system and on reducing the use of custody. 10 years ago, almost half of YJA's caseload resulted in a court appearance. Last year, that figure was just over 1/4. In terms of custody, the average daily population of Woodlands Juvenile Justice Centre was 34 10 years ago. Last year, it was 11. We look forward to continuing to build on this success and transferring lessons learned, where appropriate, into the adult sphere. In conclusion, I want to highlight the work of our staff, particularly those on the front line in our prisons and in the Youth Justice Agency. They perform an outstanding public service role, which, given its nature, is often unseen by the wider public. I want to acknowledge and thank all of the different statutory agencies and those from the voluntary and community sectors who play such an important role in our justice system. While there are many challenges, it's important to highlight that there are many areas of best practice and innovation. Thank you for giving us the opportunity to speak this afternoon, and we'd really welcome any questions you have on the issues I've raised or in any other area of our work.
Thank you very much, Beverly. Members? Doug?
Thank you, Beverly, as ever. It's great talking to you, and a lot of the things I come from is always going to come from your staff, which is the staff levels. I still have concerns about resilience within your staff levels, and particularly your night staff numbers. I'm getting reports that your night staff numbers are being reduced beyond what was agreed. Can you give us an update on night staff numbers, please?
So look, in terms of staff, we are sitting today with full-time equivalent numbers of 1,579 against an operational staffing level of 1,628. But we have to bear in mind that that staffing level was set when we had a prison population of 1,450. So what are we doing to address that? We are continuing to recruit, and we have successfully recruited at custody prison officer level and brought those levels up to just above operational staffing levels. At night custody officer level and at prisoner custody officer level, we are recruiting, and we have staff, recruits going through the Prison Service College at the moment. So by, within the next number of months, I would say by June, we will be at full operational staffing level for those areas of business. So night custody officer and prisoner custody officer. Fair to say that that's still at 1,450 prisoners. So what are we doing on that? We're reviewing our operational staffing levels, and that work is ongoing at the minute to look at the staffing levels we need to run our prisons, but also on the administration side, because over a number of years we've cut back on those administration levels, so we're looking to increase those also. But
sorry.
And to say in that, look, we have reflected that within our budget bid for this incoming year.
And staff turnaround is about 10%. 10%. What are you doing to try and get that down? So there's an attract piece to this to keep them on, because I'm literally hearing, and look, I put it out to you, is that Davis House of 400 prisoners manned by 3 night staff. How are we getting people to want to stay in if that turnover is at 10% at the minute?
And like what I have done and what is ongoing at the moment is, first of all, we have a staff survey. The first prison service staff survey is out at the moment, because I'm keen to hear the views of our staff on what we need to do more of, what we need to do better, what we need to do differently. And the results of that survey, so survey's open for another couple of weeks. I'm hoping to have the results of that survey within a month or so, and then we'll be taking action, need to take action on that, Doug. But what we are also doing is focusing on support for our staff. So Police Rehabilitation and Retraining Trust provides support for our staff for both counselling services and physio services as a separate support, in addition to the civil service wide support services that are available through Inspire and other organisations. So we provide that and recognise the pressure staff are under, recognise the additional strain that's on them, and that's why those additional support services are being provided. We've also piloted in this year with Police Rehabilitation and Retraining Trust a resilience programme, and 100 staff have gone through that resilience programme, and feedback from that has been really positive. So what we're looking to do is extend that and open that programme out wider and make it available across the entire prison service.
And briefly, that staff review that you put out?
Staff survey. So staff survey, and with the staff survey out to get the views of staff, but also our operational staffing levels are under review currently.
Yeah. Because at the last one we did, the staff deployment agreement, it said that it would be 7-hour weeks. Scotland is now down to 35. Are you planning to go to the 37-hour? We've talked about this before, David, haven't we? Are we planning to go to the 37-hour week for prison officers or not?
I don't think we would be planning to go below the 39-hour week. I mean, this was something that was negotiated some time ago.
Oh, yeah.
And it would cost the Northern Ireland Prison Service and the public purse a huge amount of money, and to actually reduce that further to the 37-hour week. Look, the POA still continue to talk to the management side about that, actually as recently as earlier this week. But I don't think it's something that is certainly achievable at this moment in time.
You can see the staff concerns. If they're doing a survey now, what comes out of the survey, will we look at it and act on it when we had a staff deployment agreement and we're not now able to? And I understand the reasons why, not able to stick with it, but look, you've been pretty clear. Thank you.
And what I will say, Doug, is in respect of our pay strategy for staff, where I have set out, in respect of my views of our pay strategy, I've sent those out to the Prison Service Pay Review Board at the end of last year. Where I'd like us to move to and intend us to move to is that we have one prison officer grade, so that gives us greater flexibility within our workforce, and would mean that you've greater flexibility around ability for staff to move within different areas of the business.
I raised that with your predecessor, if I remember rightly. Oh, listen, thank you, Chair.
Thank you. And I see in our pack today, Beverly, we've got information that the Minister's instructed that the Pay Review Board letter be published, so that'll be welcome to prison officers to hear that as well. I suppose they'll be more welcome if things weren't always behind, but nevertheless, I'm sure they'll be glad to see that. Stuart?
Thank you, Chair, and thank you, Director, and everybody for coming to us today. I've recently had some engagement with you, and that was exceptionally useful coming back into this role. Successful from the point of view of meeting staff who, despite the pressures which they are under, doubling up and all of that, are highly motivated. And I was incredibly impressed by the stories that people were telling us. Not only your staff, but also engaging with some of the prisoners as well, and listening to what works for them in the environment that they find themselves in. And despite all the pressures, there are some very positive stories inside the system. One area which doesn't seem to work very well in terms of reoffending are short-term sentences and how you manage with people who are given short-term sentences. There is a lot of good international work done on rehabilitating people with short sentences. What are you doing to enhance that service and to tackle the issue? Because more people that don't come back give you more space and resilience to do the rest of your work. I'll just pop through the rest of the quick questions to you while we're here. One area that came up in discussion when I was doing a visit was the difficulty around personality disorders, and I just want to know what particular plans you have to tackle that particular issue with those who have serious personality disorders. Thank you.
Can I just come in the back of that
Sure.
one? That was kind of one of my questions, because it arose, it arises time and time again when we visit.
Yeah.
But part of the difficulty is it's not recognised, as I understand it.
Yeah.
So not all of this is in your hands, and part of the question that I would like to tag on to Stuart's is, what do you need? What would you like to see? What can we do? Because it's okay for you to come and tell us a tale of woe, but if we're not equipping you with the tools that you need to take it forward, then you're in an impossible position.
Yeah.
Do you want to cover short sentences and then I'll talk about personality disorder?
Yeah, absolutely. Chair, you're quite right in relation to the issues in terms of short-term sentences and the difficulties it causes us. If you look at custodial reoffending, one of the big aspects in relation to the work that we do and the difficulties it causes us is the issue between the remand population and the short-term sentences, because those individuals who are in remand and subsequently get a custodial sentence, obviously when they take the time on remand plus the discount, 50% discount in sentencing, it gives us very, very little time to be able to work with them in terms of it. And if you look at the custodial reoffending rates, it is one of the areas in general that has been increasing over the last 5 years. It has raised from 42.8% to 49.1%. And a large factor in relation to that in terms of people who go on to reoffend are indeed the short-term sentence population. And part of that is because we haven't been able to, up until this point, to have an effective rehabilitation programme in place in relation to short sentences. One of the aspects that we are doing, and the pilot commenced on the 29th of January, is in relation to working with a voluntary and community sector partner to develop a bespoke short-term sentence programme in relation to those people on such sentences, and we're working with Extern at the moment in relation to that programme, which has a very focused reoffending aspect in relation to the programme that has been particularly developed in relation to being delivered over a very short space of time, but also in relation to looks at how we can develop and work with those in relation to the other factors in terms of that are in play in relation to reoffending, in terms of what you would normally expect in relation to accommodation, education, looking at addictions, and also obviously working in relation to how we support them in relation to mental and physical health. And we are looking in relation to supporting them not only within that custodial period for a very focused period, but also taking that into the community for a 6-month period in relation to supporting them within the community in relation to extern have put in for social workers to work with them specifically, because short-term sentences in and of itself are not supervised within the community, but now we have a particular team through extern working with those individuals who are coming through the short sentence programme that will be able to provide them with the support and tailor that package in relation to ensuring that they have support mechanisms within the community. So that's something that we're looking at the moment, and that, as I say, has started on the 29th of January.
Very briefly on short-term sentencing, and I very much appreciate the fact that those who are on remand have no requirements to cooperate whatsoever, and in fact quite often will be advised that as you're innocent and all of that. But we listened to the Lady Chief Justice earlier telling us about the advantages of early guilty pleas and how there's a tariff and discount for that. On a no blame basis, is it not possible or practical to have a system that says even if you're on remand, you should be able to gain some points to the point where if you're innocent, you'll have done a bit of training, why not? And if you end up being guilty, the judge could take into account some of the things that you've actually done. Is that not some of the more innovative work that is going on in other places?
And I suppose, from what you're saying, it isn't entirely possible that may be the case. I think in terms of the legal profession more generally, the issue is not the influence on the judge within a court setting, but it's more an influence in relation to the jury in terms of guilt in relation to somebody's, involvement in relation to a particular offence. If you take it, somebody may have pleaded not guilty, but if they are to engage within prison in relation to looking at an offender behaviour programme, what may a jury,
well, if you put a firewall in and the jury doesn't know.
And that's possible, but one of the things in relation to it, we do not preclude anybody from joining a programme, even if they are on remand, because whether it is a person in our care on remand or indeed a sentenced prisoner, from either perspective, they are fully entitled to be engaged in relation to the support that they need, whether it's through education, whether it's through an offender behaviour programme. They all go through the prisoner development model, which looks at their strengths and needs and risks. And they are quite entitled, if it is considered that that programme is appropriate for them, we will signpost them and allow them to go on it.
And I suppose in response then to your question, Stuart, about personality disorder, so to give you an idea of the scale of this, at 1st of March, 37% of our prison population had a history of poor mental health. And we're seeing that at an increasing rate. And the challenges for our staff are that we're not equipped and we're not medical professionals. And we rely heavily on our partners in South Eastern Trust, who have responsibility for health care in prisons, and work very closely with them and have good working relations with them within our prisons. As I understand it, the challenges in respect of mental health legislation and health legislation in Northern Ireland, and I'm not an expert in health, that would be a matter for our colleagues in health and healthcare in prisons to advise on that. But it is a growing issue, and an issue that we're seeing people more vulnerable and with increasing complex mental health cases coming within prison.
Just, Chair, that might be an opportunity for us as a committee to do a little cross-committee work with the Health Committee.
I think it's one of the areas. I think the other issue that I discovered on visitation was about access to drugs in prisons. And we've discussed it previously with regard to members having interest in the body scanners and so on, Beverly. And part of the issue that struck me was you were being asked to fight the drugs battle with one hand tied behind your back, because whilst patients are entitled to confidentiality in circumstances where a number of prisoners hold their own drugs and the prison service has no idea in what quantities, what they hold, what their baseline is, it is inordinately difficult for you to tackle the drugs problem in prison. So I think that's another area where we certainly would like to be of help.
And we have saw an increasing currency, if you like, of drugs within prisons because of the positive impact on safety and security of prisons by the introduction of X-ray body scanners. So that has made a real significant impact on prisoners bringing drugs and illicit substances into the jails with them, because they're subject to that X-ray body scan at admission. But that reduction then in drugs being brought into means that the prescription problem then becomes more of an issue for us. And what we are working with our colleagues in health to ensure that, you know, where possible and where they can and when they have the resources to do that. And I will always accept that they have the same resourcing issues as I do, that we reduce the amount of prescription of drugs which have currency and are tradable within the prison. And we're seeing that reduction in the amount of those tradable medications within prison. But of course I'd be keen to see that move at a much faster pace than it is.
No, I think that's fair enough, and I think, you know, Sir Jenny noted it, but I think it's important that the other side of the story is put, because, you know, what can you do when you don't have baseline information? So, you know, it's a rock and a hard place there, and I think that there's some work that could be done.
To give you an idea of the amount of prisoners on opiate substitute therapy across our prison system, we've around 180 on that opiate substitution therapy currently. But then there's another 100, around 100 waiting, and on a waiting list for that. So that trading of medication becomes a significant issue when you have those people waiting to get on that therapy.
Yeah, and certainly what you don't want is people becoming addicted while they're in, who weren't addicted before they went in. Who's next? Deirdre.
Yeah, no, thanks very much. Beverly, we keep following each other. I suppose the issue around remand is a concerning one, and I suppose reoffending and the match between the two in terms of particularly where they aren't receiving rehabilitation, and where there is a higher risk then of reoffending again. And obviously some of the stats in it are concerning, you know, linking education, mental health, substance use that we've talked about there, inequality issues, and obviously class. And it's just really how those are being tracked. So my concern would be around the mindset and concept within the prison in terms of addressing the cycle of reoffending. So what actions or steps are being taken, and particularly with a focus on remand, that if that is increasing, we're not going to fix the delay issue overnight. So what programmes are being put in place? And you'd mentioned there about a working group being established. Who's on that, and is that cross-departmental to reflect the complexities of cases that are coming? And just quickly, because you touched on it in terms of the body scanners and stuff as well, we've been raising issues in terms of the usage, the level of usage. I mean, obviously they're having impacts as well, and you can see that just even in the media, but just a concern around that women aren't body scanned, and is there concerns that they may be forced to carry substances as well? Has there been any issues or concerns around some of those issues, and what can be done or what is being done to address that? I mean, obviously there's the bigger discussion of a dedicated facility for women on site. So just to kind of have some issues around that, but particularly what's the plan that you're looking at, and what's the step change in terms of dealing with that issue of remand and reoffending?
So look, in terms of that remand population, we are looking at developing through the Prison Population Oversight Group and through a working group on remand, and that Prison Population Oversight Group has reps from across the justice family. Includes probation board, police, we've just recently invited, and Grania Long from Housing Executive has accepted an invitation to come onto that group. And through that group and through the working group on remand, looking first of all primarily through the working group on remand at how we can get better management information on remand, so that we know if you like, the rates of remand, what that population is made up of, what the reasons are for people being remanded in custody, as opposed to be afforded bail in the community. We're also looking at alternatives such as better use of electronic monitoring technology. So, Department of Justice about to re-tender for that electronic monitoring contract, and within that will be included an opportunity to use GPS monitoring as an alternative to remand. We're also looking at a bail support pilot because we recognise the extreme vulnerabilities of the female cohort who come into prisons and those numbers of women who are held on remand from that female cohort. So looking at developing alternatives and support packages for those women that we could present to the judiciary to give the judiciary a greater choice in respect of decisions on those individuals as opposed to putting them in remanded custody. Also developing proposals for options for bail so that the judiciary are informed on what options there are available in respect of housing and respect of health support for that cadre of individuals. Stephen, just is there anything else you'd like to come in on that one?
Just by way of, in addition to that, as Beverly quite rightly says, in terms of the management information and understanding exactly what does remand look like to us, we have developed a remand dashboard, and I can share that with the committee, that gives a very sophisticated look in relation to what remand looks like within the prison service, and not only in terms of what it looks like at any particular establishment, but it also goes through and tracks people in terms of various different aspects in relation to whether it be women, young men, etc. in terms of it. That's one of the areas. One of the other areas that we are looking at, aside from the alternatives to remand, is also looking in terms of how we can work, with our across the executive in relation to focusing in terms of it not only within the justice system but beyond the justice system, but just within the justice system in and of itself. We are looking at areas that may be an alternative to support the judiciary, so it's increased use of community sentencing, because we know in terms of outcomes that, in terms of a diversionary approach, as I was saying earlier, 49% of the custodial reoffenders who are exiting will reoffend within 12 months. But in terms of community sentences and diversion, that's down to 17%. Now, it's not appropriate in all cases in relation to it, but we are looking and working with probation to see, is it possible to extend ECOs in terms of enhanced combination orders to look as another alternative in relation to and making it viable across from where it's currently at the moment. We are also looking in relation to, and have set up a 5 Nations working group, because remand is an issue for us and a significant issue, but also in terms of increasing prison populations, it is equally across these islands is a significant issue, and we have set up a 5 Nations working group with England, Wales, Scotland, and indeed within Ireland in relation to looking at how are they addressing particular issues in relation to the prison population, what can we learn from that in terms of it, and particularly those comparable areas in terms of the steps they've already taken. When you look at our remand population in terms of percentage, which is 36%, their remand is much lower, but they have the viable alternatives already in place. But when you look at it per 100,000 of the population, it is broadly comparable overall in relation to when you look at remand in general. But that's an area we're very much focusing on to see what lessons we can learn and moving forward as quickly as possible.
Turning then, Deirdre, to your question around body scans for women, and whilst our overall approvals for body scan would allow us to use the X-ray body scans for women, we haven't done that as yet, and we are watching. England is proposing to move to that, so we'd rather learn from them. There's a very low level of radiation from the X-ray body scans, but we want to just watch and see how it plays out in England before we would consider using that with our female population. Also, in respect of that, females coming under pressure, within Hydebank, we operate a separated regime now for learning and skills, so females and males are not in education together, they're kept separately. And in respect to that female estate, if you like, where we're looking at moving to there with developments there in the future and capital developments, is that we would develop a number of independent living units to support women almost in that step down. So we have, if you like, a unit, a step down unit in Murray House, which is outside of Hydebank Prison. But what we are identifying with those women is that's a very rapid step for them. So we need to support them in that step down, if you like, preparing for release and preparing them to move back into the communities. Dave, there's maybe something else you want to say in X-ray body scans?
Yes, thanks, Deputy Chair. So, yeah, we know, we're aware, obviously, that we're only X-ray body scanning, a third of the population, obviously, at Hydebank, and we know it's a mixed site, so of course we're mindful of that. But we don't actually have any concerns that the female population has been put under pressure. I mean, it is a well-managed site. Some of the committee have seen it, really good relationships and certainly manageable numbers. And of course, X-ray body scanners are only one element of our suite of techniques, equipment, technology that we have to prevent contraband entering the prison. And in actual fact, drug test, which happens site-wide, male and female, actually would indicate that we've had the same success with drugs entering the prison or the establishment in Hydebank as we've had in our other two sites. But of course, it's something we continue to keep a constant eye on.
Just on that, David, I couldn't just ask a question about the body scanners. Have you done data analysis and research in relation to the use of body scanners? How often you use them, and the length of time someone is put into isolation in comparative to the use of body scanners elsewhere? Is there any comparative analysis
well, of
done?
course, first of all,
there has been concerns raised in relation to the amount of time someone is kept in isolation after the use of a body scanner.
Yeah. So of course, X-ray body scanners aren't new. I first visited an establishment in HMPPS, I think 6 years ago, and that's whenever we started our path to implement X-ray body scanners. The technology and the Radiation Authority is very specific about how we actually use that, and we have taken on the best guidance and brought the best possible experts UK-wide to assist us in developing that. We do realise that has increased the number of people who are held on Rule 32 because it is actually doing what we wanted it to do. But we actually took a very measured decision that there would be no other adverse impact on any individual who was in the receiving end of a positive scan. So X-ray body scanners will put people into the CSU on Rule 32, but equally it will get people back out of the CSU whenever they have a negative scan. And we obviously continue to encourage and work with people who are held in Rule 32 for a positive scan to do whatever they need to do to achieve a negative scan.
No, I understand, and I have read your guidelines and criteria. I did download them to get the ins and outs of it, but it's the length of time someone is kept in isolation and coming in and out getting scanned. Is there any variance here in comparison to elsewhere where ones could be there for a month in isolation
and
on the results of continuously getting scanned? Is that normal? I don't know. I'm asking if it's running 6 years.
Absolutely. Yes.
Is that normal?
Absolutely. Yeah.
Yes. So that it's in all of our best interests. So it's in the interest of those in prison. It's in the interest of us to ensure that people return to a normal regime and move into a normal prison regime as quickly as possible. So we don't keep people separated from the rest of the prison population unless they have a positive body scan. We retest, we rescan regularly, and as soon as that test moves to negative, then that individual is immediately moved back into the normal prison population.
Well, that's good, but if you have any data, it would be really useful to send forward the length of time, the number of people and the length of time they are kept in isolation, just for information. Yeah.
I am conscious that kind of, so you'll furnish that information.
Yes,
Deirdre, you finished your questions? Right, because just I've got a list. Morris?
Thanks very much, Chair. Thanks very much for your presentation. I suppose I've had 2 visits to Megaligan Prison, one back at the height of the Troubles, and I was lucky enough to play a few selective football games at both McGilligan and Hydebank over the years, which were very, very well looked after, I must say. But in terms of rehabilitation, what opportunities still exist within the prison service for education, higher education, job skills, placements, etc.? And are you working closely collaboratively with the local regional colleges, etc., to prepare people for opportunities to go back into employment when they come out of prison, as opposed to get into a life of reoffending? And I suppose, could I ask what prospects are there for new building work to take place at McGilligan in the near future?
I'll take the McGilligan building work first and then pass to you, Stephen.
Well, you're probably aware that we have a service level agreement in place with the further education colleges, with the League College being Belfast Met, who oversees that. So we spend some 3.6 million a year in relation to further education within our prison system. And obviously we also partner with Northwest Regional College as part of that for McGilligan. So we have a full suite in relation to education provision across all three establishments, in particular in terms of provision. Just how it links with employability, obviously, as I said earlier, we work across the executive in relation to very much focusing in terms of how we can make a system work much better. So in particular in relation to the Department for the Economy, for Communities and Economy indeed, we very much focus in relation to how we can work with employer services to align what we do within prison in relation to where employment opportunities are within the community, because we know the needs of people within our care. We know where they're going to reside on release, and we know what training provision that we have given to them. And we can align that working alongside DFC in terms of their employer services branch to link in with employers, but also in relation to the inclusion of DFC work coaches who are now working within prison establishments. They're currently working within Maghaberry. We're introducing that into McGilligan, and then we'll be introducing that into Hydebank Wood. So it's to join the system up in relation to making it much better in terms of the provision that goes through each of the establishment and then links it into an employer base outside in relation to job opportunities. One of the other areas that we're working at the moment in relation to increasing provision and that link with employers is to create an employer advisory board, where we work at the moment with business in the community, and we are looking to take that to the next stage in relation to creating a group of employers who work among themselves, and will very much mirror what goes on in England and Wales in relation to looking at like-minded employers who are willing to give people with convictions an opportunity for employment, to see how we can broaden the range of employers that are prepared to work with us and then link into job opportunity. Because what we want to do is that people go through the gate into employment, that we create that provision as much as we reasonably can in terms of moving forward.
Thanks very much. I'm sure you're aware there's a new regional college opening up in Coleraine in September, so that'll be another opportunity for you. And I think it's the Lady Chief Justice says that anybody can make a mistake, and people who have made a mistake end up in places like McGilligan, but that doesn't mean you say their life's over. If there's an opportunity that they can get back into mainstream and rearrange their life, then I think every opportunity should be given to make sure that they get that opportunity. Yeah, all for it. And you're going to tell me about new bricks and mortar.
Yeah. So McGilligan, key issue for us there at the moment is, and you'll be aware that's a very old prison estate. So key issue for us at the moment is a new kitchen facility at McGilligan. We have the outline business case nearing completion for that, and expect that to be complete by end of March, so end of this month. Next plan at McGilligan is for additional accommodation blocks there. You'll be aware we've H blocks there that go back to the 1970s. Hallward House, the most modern accommodation there. So we are looking at an extension to that block, that accommodation block, to allow us to accommodate more prisoners in better accommodation within that estate, that McGilligan estate. But it is a challenging estate. It's an old estate. It's our oldest estate.
I know. Thank you very much. Thanks, Chair.
Thank you. Ciara, have you covered yours or have you more?
No, I'll be short and sweet. Obviously, I'm very passionate about an early intervention, and obviously, I'd like to maybe focus on yourself, Stephen, and the work you do and the success that you've had. And then in comparative to Stephen, and regarding rehabilitation, and you've mentioned a range of courses that is really good, and it's imperative that there's a wellbeing wraparound programme for an individual on their journey. So when, as you mentioned, Stephen, as they leave the gate, I'd be interested in, with regards to, and it's not for now, but maybe some stats, Stephen, internally within prison and the positive impact, and maybe hear some good examples. So because I think it's pertinent to hear the good examples. But with regards to yourself, Stephen, what do you feel is the golden nugget that has really created like success? Is it the wraparound, or is there other stuff that we could learn from on the success that you have had at Just Justice?
Yeah, I think the main focus has been a shared ethos. So Child First, Offender Second isn't just an ethos that the Youth Justice Agency buys into. The Public Prosecution Service and the police also buy into that ethos, and increasingly also the courts. So there's a common ethos. The police have dedicated youth diversion officers who solely work with young people. The Public Prosecution Service has specialist prosecutors who focus on cases with young people, and obviously our whole focus is working with children. So I think that's been really critical. But it's taking that needs-based approach. So in looking at Child First, what you look at is what the child's needs are, their emotional needs, their family support, their living arrangements, their connection to education, and fundamentally the three things that are key to a child reoffending are their living arrangements, their mental health, and their connection with school. So we've done a number of things that, we've good partnerships with AODIS, Education other than at school, and with a number of schools to reconnect kids with children with education. We've used a bit of, with Rob, Peter and Paul to do a little bit of dedicated mental health work, which has been really, really successful. And we've got a clear focus on families. So we don't just support, if we go in and work with a child, we don't just support the child, we support the family. We sometimes stretch beyond, sometimes well beyond what we're meant to do, but in the best interests of the child, because we're not there 24/7, but the parents or the siblings or the grandparents are. So a lot of what we do is support the family, and that's really paid dividends. I think Beverly gave some of the figures earlier, and I think the numbers in Hydebank of young men now is about a third of what it was a number of years ago, and I think the work that we've been doing is a contributory factor to that.
Well, thank you. I think it's brilliant, and that's where we would really want to see the investment, turn it around, so less people go to prison, more people being supported at that front end. So, no, thank you, but well done.
And we are really seeing the impacts of that earlier intervention within our young males, young offender population. We're seeing reduction in numbers there, and I suppose it's once people arrive in an adult male prison, what we're seeing there playing out is, the factors that have come to play through a failure of individuals to get qualifications at school. So 74% of those within our adult population have left school with little or no qualifications, and the majority have left, without before the age of 16 or earlier. So we're playing catch up when they come into the adult population. If we can have that early intervention, that's absolutely key to driving down the numbers of people within our prisons.
I'd just like to say on that, and particularly in the education, I know the stats are there, but there is some innovative work at small scale through the Tackle Paramilitary programme in neighbourhoods and communities, and I think it's about pulling them out and seeing the success of them and how they can be expedited across the north. But there's excellent work to be able to do that type of work before they leave school as well. But no, thank you.
If you look at it in relation to Hydebank Wood, we have only 14 young men who are sentenced in Hydebank Wood.
It's really, really positive downward trend.
Justin?
Sure. 470 prisoners sharing a cell. In relation to reducing offending, what are the partnering processes for prisoners, and to what extent does sharing a cell aid or detract from potential rehabilitation, do you find?
Sharing a cell is certainly not ideal, and not, you know, our preference would be that it would be a very small minority of prisoners would share a cell, certainly significantly less than we currently have. There are some instances where it's helpful to share a cell if you have a prisoner who's feeling vulnerable and needs some support with them, and they have a prisoner who can support them, then that's helpful to have sharing a cell. But by and large, no, that's not a recommended approach, and not approach we would like to have the numbers that we have sharing.
It's just as a consequence of the...
We have no option, given the limitations of our prison estate. McGilligan Prison runs at full capacity all the time now. So McGilligan Prison runs 400 prisoners plus 100 doubled up. So, you know, it's right full. What we see when you get into doubling up and prisoners spending more time in cell, tensions within the prison environment increase, tensions between prisoners, and tension between prisoners and staff increase. So, you know, doubling up is not something we would like to be doing at the level we're doing it at.
Every prisoner is subject to cell sharing risk assessment on committal, but in respect of the number of prisoners doubled, if the role continues to rise, we're going to have more prisoners doubling up as well.
In terms of the 74% of prisoners who left school before, or at 16 or before, without qualifications, to what extent is special educational needs a contributing factor to the reason why prisoners offend in the first place? And how are you working with education? To what extent is the education department responsible for an overloading and overburdening of our prison system?
And we work with Belfast Met in delivering learning and skills within each of our prison establishments. And they have recruited and employed special educational needs advisors within the prison system. And they pick up and assess, and not just them, our staff, other partners within prison will pick up individuals who they feel have special educational needs and refer those to that special educational needs coordinator. Stephen, you really want to?
Yeah, just in terms of some of the figures to illustrate it, in terms of special educational needs, as Beverly's quite rightly said, Belfast Met have a special educational needs tutor. In terms of, in Hydebankwood College, of 176 students that they have assessed, 136 of those have been identified as having special educational needs. And in Magabry, of the 115 that were assessed, 86 of whom were assessed as special educational needs. So you'll see it is a significant factor in relation to determinant, potentially in relation to reasons why, you know, a child has left school early. And from our perspective, the early intervention prevention and how we can keep children in school has a particular significant effect, and potentially in relation to entering the justice system later on.
So an education system which is overwhelmed with demand for children with special education needs is a knock-on effect of that. You could potentially say that our prison system will therefore follow on and be overwhelmed as well. So there's a lesson there for education. In terms of the youth justice piece, you talked about the child first ethos. I'd just like to congratulate you on your successes, on the obvious compassion you have for the work and the jobs and the roles you have. So major well done.
Thanks, Justin. Just a couple from me then to finish off, folks. Thank you very much for your time thus far. In one of our reports there, I see from the Audit Office, the Northern Ireland Audit Office has said that the department has indicated that the strategic framework for reducing offending, which was published in 2013, is still fit for purpose. The Audit Office considers not, that it hasn't taken account of rising prisoner population, short-term prisoners and remand prisoners. From your perspective, and I appreciate you've touched some way on this, Beverly, in terms of the remand oversight group, what are the changes that might make a difference? If you can answer that, maybe it's not for you and it's one for the department, but just, I mean, you're the cool face.
Yeah. And look, I suppose I will always say this: if we had additional resources for staff, additional resources for those important partners that work with us on supporting rehabilitation, and that is a key issue. We are doing some really innovative work to support the rehabilitation of prisoners. Stephen has talked about the short sentence programme. Some really innovative work in respect working with colleagues in Department for Communities to bring in work coaches to support people when they leave us and preparing to leave us, and when they leave us into employment. The Make the Call team from Department for Communities also regularly come into prisons to give that advice and support to prisoners on release for them and their families around the welfare support that's available to them. The housing advisors, because a key factor in someone not re-offending is that they have decent, suitable accommodation. So the work we're doing with housing advisors, bringing housing advisors into prisons to support people to find suitable accommodation in advance of their release, are all key work that we're doing that is having a really positive impact.
I could maybe add in relation to the Northern Ireland Law Office comment about the need to update the strategy in terms of that. The issue from our perspective is one that the grounds of the strategy in relation to what is there is broadly right, and we know it's right. The Audit Office are quite right in relation to saying there are a number of factors in relation to increasing prison population remand that we need to look at that, and we're committed to bringing forward a new strategy in relation to reducing offending, and also looking at the desistance strategy of 2015 and incorporating that to bring forward a new strategy, and we'll be coming to the committee in that in due course. I have two hats, both in relation to prisons and in relation to the department in terms of reducing offending. So that is something we're looking at. But one of the other areas that the Audit Office quite rightly challenged us on was in relation to understanding how do we know what works in terms of those who go on to reoffend and those who don't. How do we know what was the material factor, whether it was within prison or something that happened within the community, or did they just mature in relation to why they went on to reoffending or not, as the case may be. And we are working across the executive to look to see, well, what information and how do we track people, who leave custody and go into the community. How do we track them to see, we know if they do or don't reoffend within that 12-month period. We'd certainly track that. But how do we track them from those who did and didn't in relation to, are there any material differences in relation to their time within custody that may or may not have had an impact in relation to them going on to reoffend? Now that's something we're looking at. We're taking that 2020-21 cohort that we use in relation to tracking to look specifically at that cohort in relation to from those that did reoffend to those that didn't, and what's the lessons learned. One of the other areas that we have tried to work across the executive with DFC and other areas in relation to looking at, can we track people for accommodation, employability or whatever, and that has just proved much too difficult because we can't merge databases in that way. But that's one of the areas we are looking at specifically for the short sentence programme. We are tracking people then that move into the community that heretofore we wouldn't have because they are not being supervised in the community, but we're tracking them through extern to see what has happened in that period of time, to learn the lessons and move that back into the custodial context to do something different if we need to.
It's going to be really interesting work, and thank you for bringing that to our attention. That's going to be really useful, and I think we would like to follow that with you, if we may. Just a couple more questions. With regard to the staff survey, given the nature of, like everywhere else, having to do more with less, and the considerable pressures that there is when prisoners are sharing, when prisoners are locked down for extended periods because you don't have the resources to take everybody to do their rehabilitation work, how do you consider staff morale is at present? What are you expecting from the survey?
My sense when I go into each of our prisons is that morale is good, but I'll await the results of that survey. and pay is always a factor.
Yeah.
And it's unfortunate that the pay settlement for this year has just taken quite so long to deliver. It will be in staff's April pay, but you know, staff have been entitled to that for some months now, and we haven't been able to pay that. So that is always a factor, and that ability to make a pay settlement early in the year to staff, I expect will have an impact on the results we get from that survey, and on the comments we get in respect of pay and reward for their services.
Well, I think it's important that we acknowledge that, you know, the prison service were at the front line in some of Northern Ireland's darkest times, when prison officers held that line, and certainly I would like to record my gratitude to those men and women who held it, and who still do in very difficult circumstances. Stephen, just a brief one for you, just in case you felt overlooked today. You only got a few questions. Stephen, on one of our papers, it is the paper that refers to, it's the youth engagement statistics for Northern Ireland, and out of the gate there, it says that there were 3,753 cases relating to young people coming into formal contact with the criminal justice system in 22-23, which was an increase of 1,266, which essentially represents 51% of an increase from the previous year. That's quite an alarming figure, bearing in mind the focus that there is on prevention and early intervention. So how do we account for this? What's going wrong? Is it not working? What's happening there? Because it's hailed as a success story, and yet we see stats like that. So how does that balance out?
Chair, we were surprised at that figure because it doesn't at all tally with our caseload. So we've done a little bit of digging within our own organisation to try and understand it. We think quite a lot of that was the police clearing up some sort of long-standing cases. So we're not actually sure that that's a real figure, because certainly our caseload has been not going up. I mean, the bit of our caseload that has been going up is our earlier stage diversion, where we're taking young people out of the formal system or not letting them into the formal system, and our statutory work has been coming down. So we find that difficult to explain, and it certainly didn't tally with our own caseload. So our current surmisal is that it's police kind of clearing some outstanding cases by perhaps doing cautions and so on, but they're not making their way to us.
Well, that's maybe something that we can take up with the police. If nobody else has anything else, and if there's nothing else, is there anything else that you folks want to make sure that we know, or anything? No, you're happy, you're content. Can I thank you all for taking the time today? It's been really valuable to hear from you directly. Beverly, I would also like to take this opportunity that prior to the committee being constituted, you were good enough to arrange visits for the justice spokespersons to a number of the prisons. We ended up not going to Maghaberry because it was going to be just me, and the committee's going to go anyway, and I appreciate there's disruption when any of us are coming into the prison. So I want to thank you for that. It was really educational, and I think the entire committee will benefit from that visit. But please do express our gratitude to the governors and the staff and everybody with whom we met, who were exceptional and really open with us, which is absolutely what's necessary if we're all to try and work together for the betterment of the system. So thank you very much indeed.
Thank you.
Thank you. Okay, members, a few issues arose in the course of that briefing and with the lead Chief Justice as well. Are you content that we then write to the department to follow up some of those things?
Yes.
You're happy enough? Yeah, we don't need to go over them. Everybody's clear? Yeah. Thank you. That's great. All right. In accordance with normal protocol, members, yes, please do feel free to refill. It's proposed that agenda item 6 will take place in closed session. Can I have your agreement that we move into closed session?
Agreed.
Thank you.
Committee Room 30. Sound. Committee Room 30. Sound. Committee Room 30, 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 Sound.
Thank you. We're back in public session. Consider agenda item 7, which is Criminal Justice Bill proposed legislative consent motions, and that's at pages 136 to 160 of your meeting pack. So the DOJ has provided a written paper on proposed legislative consent motions in relation to the Criminal Justice Bill. The bill was introduced in the House of Commons in November 2023. A number of provisions in that bill extend to Northern Ireland, which relate to a range of devolved, accepted and reserved matters and deal mainly with serious crime and economic crime and measures for the protection of victims in terms of self-harm and spiking. A list of the devolved areas for which legislative consent will be required is set out in the Department's paper, with more detailed information provided at Annex A, which is at pages 146 to 155. Information on provisions that engage reserved or accepted matters is provided at Annex B to the Department's paper, and that's at pages 156 to 160. The Department has advised that it will not be possible to include all the matters for which legislative consent will be required within one LCM, as some will be the subject of amendments that are expected to be made in May. It's therefore proposed to bring one LCM in April with a second LCM after those amendments are made in May, although time constraints may mean a second LCM is not possible. In the event that a second LCM cannot be brought, the Department has proposed a backstop position whereby the amendments passed at Westminster will be made subject to Northern Ireland ministerial and committee agreement to them being commenced. It's not clear, however, how the committee agreement will be sought in that scenario. So, as requested by the Department, we've got two options. So on the one hand, I think it's best if we hear both options and then we'll have a conversation. On the one hand, we can note the devolved, accepted and reserved provisions in the bill, indicate that the committee is content in principle for legislative consent to be sought, with more detailed consideration being undertaken when the memorandums have been laid, and indicate that the committee is content in principle with the proposed backstop position if a second LCM cannot be obtained. That's the first option. The other option is to seek agreement that we reserve our position. We invite departmental officials to give oral evidence on the proposed LCMs at the earliest opportunity and before the first memorandum is laid. And on that basis, then we can ask the Department to provide details of any consultation with relevant justice bodies or stakeholders on the implications of the extensions of the provisions to Northern Ireland. We can seek confirmation that the Department has engaged with the Northern Ireland Human Rights Commission and the Equality Commission for Northern Ireland on Article 2 implications, and we can seek clarification of how the backstop will work in practice, because it hasn't been outlined thus far, including how the committee's agreement will be on how the committee's agreement on the commencement of provisions made at Westminster will be sought. Now, I'm open to hearing your preferred options from the outset. I'm going to declare that my preference is for the second. I consider that in these circumstances, there's nothing to be lost in as much information as we can have.
Nothing, and you're right.
Nothing to be lost and everything to be gained. So are members content that we proceed with the second?
Yep.
Was easy.
That's very helpful. Thank you. Agenda item 8 then is SL1, so that's at page 162. Members, the Department proposes to make a statutory rule to set the eligibility criteria for the reappointment of lay magistrates until the age of 75, after they were previously required to retire at the age of 70. The order will be subject to the draft affirmative procedure and will come into operation following consideration and approval by the Assembly. Are members content with the proposed rule, or do you require any further information or clarification?
Content.
Content. Do you need me to read out the full title? No, we're good. All right, thank you. And then agenda item 9 is SL1, which is the Proceeds of Crime Application of Police and Criminal Evidence Order, which is page 175. Again, the department proposes to make a statutory rule to make amendments to the Proceeds of Crime Act 2002. It's the Application of Police and Criminal Evidence Northern Ireland Order 1989, Northern Ireland 2016. All the short titles and loads of brackets. Right, so these new powers relating to the forfeiture of crypto assets were inserted in the Proceeds of Crime Act 2002 by the Economic Crime and Corporate Transparency Act 2023 and are expected to be commenced on the 26th of April 2024. This order will amend the 2016 order to include the new investigatory powers with relevant safeguards in support of those forfeiture powers. It's proposed that the statutory rule will come into operation in late April or early May, being introduced as close to the wider crypto asset related powers as possible. The statutory rule will be subject to negative resolution procedure. So are members content with the rule, or do you require any further information or clarification?
Content.
Right.
Everybody content?
Yeah.
Thank you. Agenda item 10 is the Organised Crime Strategy 2021 to 24. The Department of Justice has a proposal for an addendum to the work plan, which is a written briefing. That's page 183 of your pack. Let me just get that. Members, the department tends to bring forward an addendum work plan to the Organised Crime Strategy 21 to 24, which is due to expire shortly. Do members have any issues they wish to raise on the paper, or are you content to note? Deirdre.
Around just where it talks about emerging crime types, and around 80% of the strategy actions have been delivered. So it's just to get a sense of what the other 20 that haven't been delivered are. And just a query around how these strategies link to others, so tackling paramilitarism and stuff. So just even it would be useful, or if we're going to get briefings in the future around some of this, we could even ask the questions, but to get an update on how this strategy interacts with some of the other strategies like the tackling paramilitarism.
I think that'll be helpful. I mean, we can write to the department about that, and actually we can incorporate it into the briefing then with the tackling paramilitarism programme, and they could also touch on that. All right then, happy enough?
Yep.
Okay, so forward work programme. So there's an updated forward work programme and a draft Department of Justice work programme, which are at pages 187 to 191. And then on your tabled papers, the department has forwarded a work programme at pages 3 and 4 of your tabled pack. Members, before we agree to note this, there's a few days I think are becoming a bit heavy, and we might need to have a look at those again. If, with your agreement, I would ask that the Vice Chair, the Clerk and I could sit down and have a look at the forward work programme and maybe establish what are the best days for things to be taken forward, so that we don't have really heavy days and really light days, and maybe try to balance that a bit. Are you content with that?
Yep.
Yeah, and obviously we'll work with the department on that, but we need to try and figure out our own work plan, as well as incorporate the things that they would like us to look at. Agenda item 12 is correspondence. So there's a correspondence memo and 9 items of correspondence at pages starting at page 193. I'll draw your attention to one of the items, and then you'll have an opportunity to comment on any other items of correspondence in which you have a particular interest. So the one that I want to draw your attention to is at item 3, which is page 204, which is a response from the department regarding plans to amend the limits for items to be excluded from asset criteria for the purposes of debt relief order. The department has stated that the power to amend eligibility criteria rests with the Department for the Economy. I would ask that we note this item and then ask the Department for the Economy if it has any plans to amend the limits for items to be excluded for the purposes of a debt relief order. Are you content to note the other items as set out in the correspondence? Well, first of all, let's deal with this one. Are you content to note the response from our department and write to the Department of Economy?
Yes.
Yes? Okay. And then with regard to the other items of correspondence, do you have any comment to make on any of them? No? All right. So if I can refer you to your tabled pack. item 12.11 at pages 6 and 7 of your pack, you'll note that the Minister has advised that she's asked the Prison Service Pay Review Body to publish its report on the pay of operational prison grade staff for 2023, which is a welcome step. Members agree to note?
Noted.
Thank you. Item 12.12, which is page 8 to 21 of your tabled pack, Sejini has laid its report on inspection of community safety and local policing arrangements in Northern Ireland. Are members agreed to note this item? If there's anything you wish to raise in that, I'm sure we can highlight that whenever the Chief Constable comes. So, Chairperson's business, I have none. Any other business? Stuart?
Just very, very briefly, you will have just received from the Business Office an invitation to the commencement of a new all-party group on access to justice. However, they've sent it out with that title, but it's actually an invite to some climate change meeting. They seem to have mixed up the dates and the times, and go back to them in respect of that. There will be a date, and there will be a prospective all-party group on access to justice, and clearly it should be of interest to Justice Committee members, and they'll be encouraged to come along to that, and it will be facilitated by the Law Society and the Bar Council.
So, the last item of business is agenda item 15. So, the next meeting will take place on the 11th of April in this room. The other thing that I would flag up to you, members, please note this. The meeting's going to begin at 1:30 p.m. and that's going to be the briefing from the Bill Office with regard to the implications of the Department's plan to introduce significant provisions of a bill at consideration stage. So it's important that as many of us are here as possible. Please note that in your diary. So that we don't that as many of us are here and we don't miss that briefing. It's important advice. And then the formal meeting will begin at 2 p.m. So if you put that in your diary, that's the 11th of April in this room at 1:30 p.m. Okay? Members, that's the meeting adjourned. Thank you. Thank you.
Committee Room 30, sound.